Good afternoon, everyone. I am very glad to see you at our webinar dedicated to appeals chamber reform in Ukraine. My name is Mariya Ortynska. I am patent attorney, trademark attorney, attorney at law, and managing partner of IPStyle, an IP boutique that deals with protection and enforcement of intellectual property rights. Today, I will share with you what is going on in the field of intellectual property in Ukraine. We will be speaking about what awaits us and what we should pay attention to. I would be very grateful for your questions, for comments and discussion. And you can write all your comments, questions in the chat. Anyway, after my webinar, my colleagues will send their presentation. So let's begin. One moment, I will open the presentation. Okay, let's begin. At our last webinar on trademarks, we talked about the fact that in the last year, changes were made to the intellectual property legislation twice. Thus, the law provides the establishment of the national body, National Intellectual Property Authority. But such a body was never created, and for the time being, by the order of government, the functions of such a body are performed by Ukropatent, Ukrainian Patent Office. Also, the same law provides for establishing for some collective bodies at the National Intellectual Property Office, and of course, the most important is the appeals chamber. And recently, it's last year, new regulations for appeals chamber came into force. And today we will stop on these regulations, what we shall await about this new body, new procedure, new possibilities, and new risks. I will first speak about some significant changes and new possibilities in general, and then we will talk separately about trademarks, designs, as well as inventions and utility model changes. So here you can see some new functions of the appeal chamber. So concerning trademarks, it's consideration of objections filed by persons who filed opposition against trademark applications. Concerning designs, it's cases of invalidation of registered designs. So previously we could do it only by the court. And speaking about inventions and utility model, it's the same situation, cases on invalidation of patented utility models in inventions. Actually, previously, these also could done only in the court. Other functions such as consideration of final refusals of all industrial property objects, as well as recognition of trademarks as well known, they remain. When we talk about rules and procedure, I want to draw your attention to the following. First of all, it's language of consideration. It is Ukrainian. Of course, in the past, all applications and all not court hearings but chamber hearings were also in Ukrainian, but sometimes we could file annexes, some written documents, supporting documents in other languages. For instance, in case where the essence of submission of some web page was only to show availability of goods with the appropriate trademark, we could not translate all documents, all web page, and so on. But thus, according to the new regulations, we need to translate into Ukrainian all annexes and all additional documents. The second thing is power of attorney. So it's also a simple written form with no notarization and legalization. We need to file also original of this document and bilingual or with a translation into Ukrainian language. The next point, it's very new for Ukraine, it's independent expert. Actually, under the new regulations, their appeals chamber may at any time involve an expert. I mean, not expert from the Ukrainian patent office, but maybe court expert or maybe other specialists in its consideration in order to clarify the circumstances that are important for consideration and require special knowledge in the field of science, technology, or art. Actually, it can be done at the initiative of the appeals chamber or at the request of a party. And if you, like a party, request it, it means that you will reimburse the cost of involving such an expert. Actually, independent expert will have some opportunity to provide opinion about some topics, for instance, about some technology, some novelty, and so on, and also provide some explanation to the appeals chamber, participate in their appeal hearings, and even ask the questions to the party. Actually, we think that this provision has been adopted more in the context of inventions, utility models, and designs, because in such cases there is more requirement to have maybe some technical expertise. But formally, there are no restrictions of the involvement of an expert in trademark cases. And last point in general, before we start speaking about trademarks, designs, and so on, it's actually, the deadline for providing evidence right now is clearly defined, and the evidence must be submitted together with the first statement of the merits. It can be objection, appeal statement, application for recognition of the trademark as well known, or statement of defense. And if evidence for some reasons cannot be provided, you need in the first statement of the merit to show this possibility of submission and to define some reasons for such non-submission. And if reasons are valid, the appeals chamber will accept the evidence later on. And what is also interesting for me and for our jurisdiction, it's additional evidence. According to new regulations, appeals chamber may also invite the party or the applicant to provide additional evidence, and in some cases, on their own initiative, can collect evidence. For instance, in cases on the recognition of trademarks are well known, or an appeals against decision on trademarks by both applicants and people who filed their positions. Actually, for invalidation of utility models, invention designs, such rights to collecting evidences are not provided. So let's move to some specific objects. For instance, we will, first of all, we will talk about trademarks. Trademarks is the most popular object in Ukraine. Here you can see some statistics about applications, number of applications that have been filed in Ukraine in last year, and you can see a number of Madrid Protocol applications and national applications. Actually, speaking about trademarks, previously and right now, appeals chamber will consider, as it considered before, objections against final refusals to register trademarks, application for recognition of trademarks as well known, and objections against final refusals to register trademark. But it will be some deadlines. For instance, speaking about objection to refusal by applicant, it will be a deadline 2 months from the date of receipt of the final refusal for application filed by national procedure, and 3 months from the date of sending the YPO of refusal for applications filed by Madrid Protocol procedure. But what do we need to do if we want to extend this term? Now I want to share with you one tip on how to extend the deadline for appealing to the appeals chamber. It can be done only for trademarks by national procedure, but a lot of foreign applicants, they also prefer to file application by the national procedure. If you file trademark applications under the national procedure, you can, within a month from receiving the refusal, request copies of the materials of a proposed trademark. And in this case, a 2 months period will start not from receiving the refusal, but from receiving copies of such materials. But unfortunately, for international applications, you can get a copy of such materials, but the deadline for submitting objections cannot be extended in such a way. And please be aware that if you file, for instance, if you received a partial refusal and partial decision, and if you will pay issuance fee, you would not allow to appeal to the appeals chamber. So what usually we propose to do, first option is to wait and submit an objection to the appeals chamber. And another, if you can't wait, you can divide the application and they pay the issuance fee for divided application and object to the refusal to the appeals chamber on the other application. Speaking about money and time, consideration in the appeals chamber is faster and less expensive. Here you can see that fee for filing objection is 125 United States dollars. And in case of satisfaction of your objection, the fee for filing of objection shall be refunded in the amount of 50% of this fee. If we will speak about court fee, this fee is correlated, but usually there are more court hearings, and so the cost of legal aid is usually higher because our courts are very busy, and sometimes it's not like 1, 2, 3 hearings, but more. Speaking about terms of case consideration, if you go to the appeals chamber, usually case consideration is from 2 months to 4, but in court, deadlines are not set. And usually the courts are sufficiently busy, and frankly speaking, process can take a year or more. I think it's like in other countries too. But you need to be aware the decision of the appeals chamber can then be appealed in court within 2 months from the date of receipt of the decision. Speaking about procedure for appealing decision of the registration by a person who has filed an opposition. Let me remind you that from August last year, we have a new procedure of oppositions. Actually, speaking about oppositions, we have clear deadlines for filing oppositions because previously, 2 years ago, 3 years ago, we didn't have some clear deadlines for filing oppositions. So right now it's 3 months from the date of publication of the application. And when an opposition is filed, applicant has the right to respond to the opposition, like in many countries. If we speak about national applications, it's 2 months from the date of receiving of opposition. And speaking about international migrant protocol application, within 3 months from the date of sending the notice of provisional refusal together with a copy of the opposition. Previously, if a person who files the opposition against the application, in case a positive decision was made on it, did not have an opportunity to appeal against such a decision to the appeals chamber, he could do it only by through the court. But amendments provide that a person who has filed an opposition against application may appeal to appeals chamber regarding a positive decision that was issued to the trademark application. Actually, in case we can see that it's like post-grant opposition, and it's very important process. It's a new one for Ukraine, and parties to this procedure are the person who files the opposition and the applicant. Also, we have some deadline for filing such objection. It's 2 months from the date of receipt of the copy of decision. But speaking about oppositions, opposition process in Ukraine is purely written process. The appeals chamber is a combination of filling written documents and oral evidence, so we expect that it will be very effective, and all parties can argue, can provide their arguments, and we hope that appeals chamber will have a very good opportunity to consider case properly. Speaking about what is going next, the applicant, if the person who filed an opposition appeals to appeals chamber, the applicant has the right to file a statement of defense. And deadline for such statement of defense is very short, only 15 days from the date of receipt of notification of objection. Of course, if you cannot file maybe statement of defense, or maybe if you need some time to gather more evidence, you shall submit some information and some applications that you need more time and indicate some valid reasons. By the way, theoretically, there may be situation when a partial refusal is made and both the applicant and the person who files the opposition disagree. In such case, our rules say that appeals chamber consolidates objections in one proceeding. In general, what I want to also pay attention, if you have filed a opposition, you can appeal the decision on this application. Both you and the applicant will take part in some proceedings. But if you have filed an opposition and the applicant is appealing the decision on the application, only as the applicant will take part in such proceedings, but not you. Unfortunately, this is prescribed by law, and the new regulations cannot go beyond the limits established by the law. So, in very short, it's our new procedure speaking about trademarks. If we go to designs, as before, the appeals chamber is considering objections to final refusal to register designs. But what is new, that this appeals chamber will consider statements of invalidation of design certificates. Previously, we can do it only by the court. So you can see that according to our regulations, any person may apply to the appeals chamber for the invalidation of design. Statement of the design invalidation may contain the design certificate in full or in part, for instance, only for 1, 2, 3 or more designs in the whole certificate. This statement of the design invalidation may be submitted during the entire period of validity of the design certificate and even upon their termination. For instance, if person understands that, for instance, if person was accused in violating design rights. So it's a very, very important change, and I think that in future we will have more and more cases of invalidation of design certificates in Ukraine. And I would like to draw your attention to this possibility about this term, the entire period of validity of the design and even upon their termination. If you decide to invalidate the design certificate in court, you will be restricted by the limitation period provided for the procedural codes, commercial and civil codes in Ukraine. It's 3 years after you have learned about the violation of rights. But if you miss this 3-year term, the law does not restrict you from applying to the appeals chamber. Actually, in general, I think that this is good possibility to invalidate designs, and it's a very good opportunity to fight patent trolls more effectively. Maybe you know that in Ukraine there are a lot of patent trolls, but usually they are not patent, but like design trolls. So they prefer to register on new designs, appearance of different scenes, then entry them into customs register, and then block export and import activity of other companies. Actually, what also is very new for our law, and it will be very effective for the fight against patent trolls, it's ban on re-registration of designs recognized by a court on the appeal chamber as invalid. So if you started validation proceeding in the appeal chamber on the court, and this design was recognized as invalid, if the same person will file the new application with the same design, he could not do it, and it will be prohibited to do it. So actually, I think it's very important also provision in our law. Speaking about invalidation procedure itself, we have some parties. It's a person who applied to the appeals chamber, and of course design owner. A design owner has the right to provide a statement of defense also within 15 days. Further, within a reasonable time, it's not set clearly deadline. Parties also can exchange documents. The person who appealed to the appeals chamber may file a response to the statement of defense, and after that, IP owner may object to this response. If we speak about inventions and utility models, the similar situation. Previously, our appeals chamber consider only final refusals, and only applicant could file some appeal to the appeals chamber. But right now, this appeals chamber will consider the statement of invalidation if they are submitted concerning inventions within 9 months from the date of publication of information of patented invention, and concerning utility models within the term of the validity of utility model patent and after their termination. And the procedure is quite similar to the appeal of designs, but I want to pay attention for 15 days, because if, for instance, you are a patent owner and somebody start proceeding against your patent, you will have only 15 days to file statement of defense to provide translation of all supported documents into Ukrainian and organize the whole process. For me, it's maybe speaking about inventions and utility models. It's rather short time, but it's prescribed by our provision. Speaking about the appeal consideration itself, it's a combination of oral and written arguments, and the regulations provide for debate. That means, in essence, that it should be very effective, competitive process. And this decision of appeals chamber, of course, may be challenged in court, but within a limited period, only 2 months after the date of receipt of the decision. And in order for you to make it maybe more convenient, we prepared some table of terms when you can file objection to the appeals chamber and concerning different types of appeals and different objects. And my colleagues will send you this table with our presentation. And to sum up, maybe in conclusion, I want to share with you some my expectation. What I think that number of opposition and then appeals to the appeals chamber on trademarks will increase. Because new procedure of oppositions and new appeals chamber, it will be very effective. But the possibility of invalidation designs, inventions, and utility models will unload the code. And I will be very honest with you. My main concern about all this is the future of intellectual property code. As you can see, the appeals chamber essentially duplicates the functions of the RP code, which is created on paper, but in fact not yet. Doesn't this mean that the code will never set up? Actually, I don't know. We will see what will be in future. And it's like a brief overview of our procedure. I hope that you are not tired. And in last slide, you can see our contact details. And if you have any questions or comments, we can discuss, or maybe you can write them on chat. I know that there is some, I try to, one moment. Some questions, okay. Mariya, question for you from the attendees. Can their 15-day deadline be extended? Now this 15-day deadline cannot be extended, but maybe if you will have some valid reasons, the appeals chamber will let you do it, but actually our provisions are not regulated this question, and there is not like some procedure to extend or to renew this term. And where to appeal opposition decision, if I understand you correctly, you can, if you received a decision for a refusal or a positive decision, if you filed an opposition, you can go to the appeals chamber, but if you are not satisfied with the decision of appeals chamber, you can go to the court. Maybe some other questions? If not, so for those who have evening or night, I wish a nice evening, and for those who have daylight, I want to wish you a nice day. Take care, and I hope to see you later.